Good morning, Mrs. Barnes. My name is Dan Tuffin and I'm the panel chair. With me today on the panel are Mrs. Esan, who is the lay member, and also Judge Adamson, who is the judicial member. Welcome to your interview today for the post of fee paid judge in the employment tribunals. In this interview, questions regarding the ability to understand and deal fairly will be asked by Mrs. Esan, along with questions on authority and communication. Please illustrate these abilities with examples. We're not looking to catch you out. Also, we will be taking notes throughout, so please bear in mind at times our heads will be down. Are you ready to begin?
Yes, thank you.
Great. Then I'll pass you over to Mrs. Esan.
Thank you. So regarding the ability to understand and deal fairly, can you give me an example of when you've had to intervene to ensure fairness of treatment?
When I worked for Hargreaves Solicitors, who do a lot of trade union work, I was the workplace representative. At the time I was there, Hargreaves was merging with another firm of solicitors, Smithson's, and this resulted in redundancies for some of the employees. As our work involved working with trade unions and employment law, I didn't think there'd be really any issues to deal with regarding these redundancies. However, I was contacted by a woman, an office assistant in the Bradford office of Smithson's, who said she was concerned that she would be targeted for redundancy on account of her poor language skills, and there was also a racist undertone to her feeling that she might be selected. She felt that they were trying to engineer her redundancy instead of addressing her issues directly, so I helped her deal with that.
Okay, and so what did you personally do to ensure she was treated fairly?
Well, I contacted the management at Smithson's and established that they hadn't made any final decisions about the redundancies, and also that they were going to employ very specific criteria, and that her language skills and race would not form part of that. I then fed this back to her and made it very clear that the criteria was going to be used very robustly and that her language skills would not form a part of any such decision. She was happy with my advice and is still working there today. And I also suggested that she speak to her line manager regarding her language skills, which she did.
Okay, thank you. Can you give me an example of when you altered your usual approach to deal with the situation?
99% of the work we do at Hargreaves is done on the phone, as is the norm with employment work for trade unions. It's a loss leader, but we do it because of the PI work that we get. So the arrangement with trade unions was always to deal with people over the phone. However, my colleagues and I had a policy which was to always deal with members who had mental health issues face to face, especially when turning them down for help. I had one particular client who had a number of disabilities, including mental health illness, and had also recently lost her 21-year-old son to liver failure. In her case, we met up face to face as I explained that we could not take on her case because there was no reasonable chance of success, and that's the criteria by which we were able to take on cases. I subsequently had a lengthy phone call with her, during which time she told me about the death of her son, and we would normally try to keep the length of the phone calls reduced in order to reduce the costs.
Okay, so that's what you would normally do. What did you specifically do in this case?
Well, in her case, I listened until she'd finished. I then spoke to my line manager and explained why the call had taken so long, and he agreed not to charge the full time to the trade union.
Thank you. We move on to authority and communication skills. Can you describe a time when your authority has been challenged?
When I was working at Hargreaves, I was responsible for training some of the regional representatives and employee representatives and regional officials in employment law. Some of the regional representatives, well, most of them, they tended to be sort of older men who were quite authoritative and who knew everything that there is to know about employment law, and didn't particularly appreciate a young female lawyer coming and training them in it. On one occasion I was giving a lecture to 150 employee reps and regional representatives on age discrimination, which was a new law that had come in at that time. And one regional rep kept asking me about one particular detail of the Act, which I was not familiar. And even though I explained that, I would find out the information and feed it back to him at a later stage, he kept going on about it. I decided then to explain to the audience as a whole that I was there to give them an overview of this Act and that I didn't have all the information to hand, but that I would go away and find it out and then give it to them at a later stage.
And how did you deal with the regional representative?
Well, I spoke to him afterwards separately and asked if he had an issue with my training. He said he didn't, but he said he'd like to have all the information in case one of the employer reps then asked him for it. Once I challenged him face to face, he backed down and became much more polite. And also, I felt that because I addressed the audience as a whole and explained the situation, that took the wind out of his sails.
Okay, could you give me an example of when you've had to describe a complex legal issue to someone who had no legal background?
Yes, when I was at Hargreaves, I had 5 claimants who worked in estates management, and their work was being transferred from one company to another under an outsourcing arrangement. The dispute was over whether or not they were being transferred under TUPE arrangement.
Could you explain TUPE to me, please?
Yes, TUPE refers to the regulations regarding the transfer of undertakings, protection of employment. It's used to protect employees who are moving, whose business is being transferred to another business. The dispute with this transfer was that if they weren't being transferred under TUPE, then it would affect their compensation rights, etc. I wrote to them and explained the situation in simple terms, and then followed this up with a face-to-face meeting. And I explained how TUPE works, and that they've fallen into a gap. Their previous employer was insisting that it was TUPE, but their new employer was disputing this. They'd taken their claim to an employment tribunal, and I explained that this was the sort of issue that would be decided at a pre-hearing. I told them that the claim was against the new employer for not accepting the TUPE handover, and that the employment tribunal would look at the issue and at what documentation, etc., would be needed to resolve it. I also explained what they should be trying to find out at the pre-hearing.
Okay, and what was the outcome for the employees?
They were satisfied with my advice.
Thank you.